So this is the second part of Section 5, which we're looking at some practice issues related to injunctions and really trying to focus a little more closely on the actual procedure that the court will follow and that you may have the ability to insist on with respect to the practice of issuing a preliminary injunction. The two rules that we're going to look at a little more closely today are Rules 52, findings by the court, and then Rule 58, entry of judgment. With respect to findings under Rule 52, anytime a case is tried without a jury, under both Massachusetts and Federal Rule 52, the requirement is that the court separately set its reasons for its decision and make both findings of fact and conclusions of law such that one could look at those findings of fact and conclusions of law and see both the evidence that the court found that factually supports the court's decision, as well as the law that does allow the court to do what in fact it is ultimately doing. As I said to you last class, while in most cases they are written findings of fact and conclusions of law, the rule doesn't necessarily require that it be in writing. Sometimes the court will in fact actually orally issue its findings and conclusion and its decision into the record verbally, and that is sufficient to satisfy the rule. The fact is, though, there has to be that process so that one can look at what the court found in coming to its actual decision. A lot of times, in a lot of cases, when you actually try them before the court and there is time, like a divorce case where you're not seeking injunctive relief and the like, the court oftentimes will ask you to submit, just as we saw in the Pier 4 case, findings of fact and conclusions of law. Oftentimes they're going to do that at the conclusion of the case, because until the case has actually been tried, you don't know what evidence the court received, you don't know where the references to testimony would be because there hasn't been any testimony yet. So a lot of times when the case is tried without a jury, there'd be findings of fact and conclusions of law submitted after the fact, as it happened in the Anthony's Pier 4 case. Sometimes, and if it's a relatively short trial, the court will ask you in advance of the trial to submit proposed findings of fact and conclusions of law. The conclusions of law are less problematic at that point because we all should know what law we're using to arrive at, that the court should apply in arriving at its decision. The problem with submitting proposed findings of fact in advance is you don't have all of the references to where that evidence would be found. You may have pre-marked exhibits and things like that you can make reference to, and you can make reference to what you expect the testimony will be from each witness, but until such time as the witness testifies, you don't know that that's in fact precisely what it'll be. When the court asks for them in advance like that, it does give the court the ability to look to make sure that evidence comes in, and it obviously would allow for a quicker decision as a general matter. It's a different process if that's what they're doing. If that's what they've requested, it's more concrete and clear if the findings are done with the trial record and the transcripts and the like. But it's actually a much harder job because everything has to be documented throughout where that each piece of evidence is found in the record itself. So what Rule 52 says is that if the court makes these orally or in writing, at the end of this process, whatever judgment the court issues with respect to the matter that's being tried, they still have to issue, even though they might issue the conclusions of fact, the conclusions of law, the findings of fact, and even a memo that would support advance its decision, there still must be a separate judgment entered under Rule 58. And so Rule 58 is oftentimes sort of an overlooked rule because it seems, and it is for the most part, a perfunctory part of the process where what this requires the court to do is that to issue a separate judgment on a separate document. So whatever it ultimately does, if it grants the request for a preliminary injunction, that there be a separate piece of paper that evidences the grant of the order and what it says, and then that order, by way of Rule 58, with the judgment being entered on the record, at that point it's clear what the court's order was. It's also clear from the purposes of appeals and timing what the date of that order is. So just because you have findings of fact and conclusions of law doesn't mean you have a judgment yet. You've got to get a judgment, and that's the way that works is separately under Rule 58. The court, by way of a separate document, will issue whatever judgment it is issuing. And then at that point, timing starts to run, and you've got to now start to be careful if you're thinking of considering an appeal, or if you want to pursue the compliance with that judgment and the like. You then have to look to obtain an execution if it deals with money at all. But the 58 is really the last part of the process here, where the court separately issues whatever the court's judgment is. And until they do, the order isn't appealable because there is the requirement that judgment issue separately and be recorded on the docket separately, so that at that point in time, your time limits for appealing the order and everything else have been put into place. So both rules become important. Rule 52 becomes really important and an awful lot of work because what you're doing is you're assembling all the information as to why you should win and the other side should lose. And it is a very labor-intensive process in any type of involved case whatsoever. But what you're doing in that, as part of that process too, is making the court's ability to find for you that much easier. So anytime you have a non-jury trial, and whether it's a request for injunctive relief, whether it's a divorce case, whether it's a money case that you're just not trying to a jury because either you've waived the jury or statutorily you're not entitled to it, then the court has to make findings of fact and conclusions of law under Rule 52 so that we understand what both the factual and legal basis for the court's decision. Okay, questions on Rule 52? Questions? I mean, if you think about how it compares to a jury trial, in a jury trial, we would submit proposed jury instructions to the court. Conclusions of law are just written a little differently, but it's basically the same process for a non-jury trial. What's different about it is that we submit these proposed findings of fact as well, and we don't do anything of a similar nature to the jury. The jury is expected to figure out what the facts are that are important based on the opens and the closes and all the rest of the information that's submitted before them. Questions? We all good on that? So one last thing that's on the agenda for today, and I want to talk about it because it's mentioned in the Republic of the Philippines case as well, is this idea of magistrates and how that works in the federal court. And so it's something that you should start to think about because you're closer to the end than the beginning at this point. The magistrate process in federal court works like this. Every federal judge, when your case is filed in federal court, it is immediately assigned to a federal judge who will see that case from beginning to end. So unlike the state system where your case could be before any number of judges and it doesn't stay with that judge, that it's a much a more hit or miss process in the state system as to what judge hears your motion for discovery disputes, what judge hears the summary judgment motion, and what judge might ultimately be the one that sits for trying the case. And it's actually it can be problematic. Sometimes it's less problematic if you get a good judge that goes your way and then you want to try and get it back to that judge for other parts of the proceeding, but it's not always possible. In federal court, when we enter the case, they give us a docket number. As part of the docket number, it is assigned to a judge. At that point, from that case forward, that judge is responsible for that matter. Now, with that said, every federal judge also has a magistrate that works with them. And the magistrate really you could think of it as sort of a mini judge. And a lot of times the magistrates will handle all discovery disputes. They'll handle some of the motions as well. Some judges require in the federal system, require virtually everything to go to the magistrate before it ever gets to the judge. You can also, if you so choose, decide that you will try it before the magistrate, and then the magistrate will make a recommendation to the judge, and the judge can decide to go forward. I don't like the last part of the process. Why should I have to try it twice to win? The fact is that I know who the judge is. I know their background, and I can do the same for the magistrate. But why do I want to reinvent the wheel why do I want to do things twice? And the answer is I don't. So from my standpoint, oftentimes, to the extent I have been able to say, no, we'll prefer to see the trial judge. That's my preference. Sometimes for some discovery disputes, they say, nope, you cannot. They want the magistrate to talk to you folks first and see what the issues are. But beyond that, I just want you to be aware of this process, that sometimes some judges are going to try and make sure that you utilize the magistrate process to a greater extent. In some cases, that's going to be a great thing if the magistrate is very good. At other times, it's going to be just another hurdle to get to where I need to be. And which means an end result. Try the case one way or the other, up or down. Because I was taught early on that if you are a plaintiff, the idea is to get to trial as quickly as possible. And my experience is that whether we try it or settle it, oftentimes the things don't resolve until we're relatively close to hanging. That's when people think a lot sharper about the possible consequences. The lawyers have made whatever money they're going to make. And at this point now, it's just a lot of work from here on out. And that's when good things generally happen. So to the extent that we're going to place another 6-month process between that and actual trial for a final decision, to me that never benefits a plaintiff. Delay always benefits a defendant. Now, I'm sure some would say, well, that's hyperbole. But okay, they're entitled to their opinion as well. I don't see it that way. I think that from a plaintiff's perspective, your job virtually always is get it to trial as quickly as possible. So to the extent I can avoid the whole magistrate excursion, that's always been my preference. There are some times where you can't, but if they give you a choice, do you want, because you could, the theory, the magistrate has a less crowded schedule. You could jump, to the process a few months. But if I still have to end up back at the end of the process still waiting for that judge, either because we don't like the decision, we don't think it should be adopted, or they don't like the decision and don't think it should be adopted, then so how did I save any time here? I've just given the other side a couple cracks at defeating me. I just want to caution you about it, because I don't think it's something we see a lot, But in federal courts, they use the magistrates for a lot of the work that a judge would normally do. And the magistrate is a judge who can do a lot of that, but to me, it slows the process down a little bit. Magistrates do a lot of the mediations and the like. And that's, I don't care who does, well, I was gonna say I don't care who does the mediation, but I do. To me, mediation with judges or retired judges, magistrates fall into that same category, is always better, because I think the clients listen to them better, I think the lawyers will listen to them better, I think they have more experience with adjudicated results, meaning if that's the choice, is if we don't settle, we're gonna try it. I think it's more helpful to have some of that experience than, sometimes you have lawyers who agree to serve as mediators, sometimes lay people in some courts for some disputes. To me, the most effective and certainly the ones that I think have the greatest ability to be able to bang heads around and get them to think about issues that are important related to the case are either magistrates, judges, or retired judges. Retired judges bring some gravity to that process. I'm assuming all of that is free. Most of the court processes now involve the magistrates and the retired judges. As a general matter, your assigned judge wouldn't probably not want to take part in federal court, take part in that mediation process. But a lot of times judges try to bang heads and get people to really think about whether they want to go forward. But from a standpoint of using the magistrate for mediation or conciliation, I've done that a number of times. Sometimes it's helpful, sometimes it's not, but they're experienced, they understand what likely goes on in that court and what the results are more often than not, and so I think everyone listens to them to a greater extent, and I've had some success there. And so that's, to me, a better use sometimes of the magistrates than certainly the pre-trial trial type of thing. Questions on magistrates? Sometimes magistrates then advance to judges down the road, but many people see them as virtually the equivalent, that just about, not fully, but just about.
So clerk magistrates in the state court, their responsibilities are kind of similar?
Less so. Clerk magistrates in the probate and family court and the state court will hear maybe show cause hearings. They'll hear some discovery disputes in the federal court, in the probate court. They'll do a lot of scheduling, Rule 16 pretrial conferences and the like. And that in that way, it's similar. But the powers of a magistrate in federal court are even broader than that. We could, for instance, choose, say we have a case that's in federal court before Judge Wolf, we could agree that instead of trying it before Wolf, we'll try it to the magistrate first to see where we can get to and what the magistrate's findings would be. If it's done that way, then the court has to make a determination subsequent to that whether to adopt the master's findings or not. So in essence, there's still that process that the judge would review it, but why am I doing it with a less experienced hand? And why am I agreeing to a process that gets me less than the full trial before the federal judge with the jury, with a more experienced trial judge? Speed, a little bit, I guess, maybe in part. Maybe I think the magistrate might be better for my case than the federal judge, and that's a possibility too. But I don't see why I should have to do it twice, and that's my problem with it.
Now, what about, I know it's this is civil, but what about criminal? Now, the clerk magistrates.
No, the magistrates might do an arraignment. They might listen to your pretrial conference, but the trial is going to be before the federal judge. Magistrate in the state court, as you referenced, state court magistrates do a lot. It's just that the last part of the process almost always is going to be before the judge, where in the federal court, they have this process where you can agree to the trial before the magistrate. And I'm not sure I've ever seen that really in either probate, superior court. I don't think you would, even the district court. But with that said, your show cause hearings as to whether a complaint should issue or not, those are only before clerk magistrates in the district court. But once they issue, then the judge is going to be hearing the rest of that case. Let's look at the original Great American Chocolate Chip Cookie Company. And again, we're focusing sort of on the procedure here that's employed and what you're entitled to get from the process, and as to procedural safeguards and protections. And this case was, as you can see, that there was a magistrate involved in this process. So we're in federal court, and it's on a request for injunction. And then we start out with the order granting injunction says it shall describe in reasonable detail and not in reference to the complaint or other document the act or acts sought to be restrained. The magistrate judge in this case, who did get the first crack at it, recommended that the district judge grant the Siegel's motion for PI, and then the district court judge did just that. So he followed the recommendation of the magistrate. But if you look at the little process here, it's a two-part process then. So I've got to convince the magistrate, and then I still have to get the judge to sign off on it. So if it's required, that's one thing. But if I can get to go to the guy who's going to make, or the woman who's going to make the decision in the first instance, why the heck not? But some judges are going to insist on that process, and you can, with others, you can agree to that process. You can decide what you think is best. But it says, the magistrate judge's opinion contains no actual injunction order, however, and the judgment order entered at the direction of the district court states in its entirety, the district court adopts and incorporates Magistrate Judge Bucklow's report and recommendation, and that's what it is, right? The magistrate makes a report and recommendation to the court as to what they would do with it, and then the court can either accept it or reject it. And that's what happened here. And then, so it says, and there was no injunction order, but merely an incorporation by reference of the draft of an injunction contained in the Siegel's motion. This fell far short of compliance with Rule 65D. I want to back up for a minute so you understand why this is problematic from the outset. A preliminary injunction carries with it the threat of contempt, right? If you don't comply with the court's order, you are in contempt. We're going to look down the road and see, well, that can be civil contempt or it could even be criminal contempt. But in order to show that an individual is in contempt of the court's order, there has to be a clear directive as to what to do, and then there's got to be a failure to comply with the directive, right? While you're able to comply with that directive. So when we talk about Rule 65 requiring, when a preliminary injunction issues, a separate, clear language as to what is being ordered, part of it, the reason for it is because of how do we enforce the order if we don't know what specifically the individual was charged with. And the other part of that is, in a fairness principle, is how does the individual know what they can and can't do if that order hasn't been specifically, they haven't been specifically informed of the order. So when you want a preliminary injunction, if you're, whether you filed your complaint and now you bring your motion and you support it and the rest, you need to start to think, what precisely do I want that order to say? Because, for this reason here, but B, there's a lawyer reading that order on the other side. And they're going to tell their client what they can and cannot do consistent with the order that the court has given. If you want to prevent certain activity, then that order has to be precise about what you're asking it to do, and you've got to get the court to issue such an order. And I need you to think about from the notion that some other lawyer is going to tell them how to bend and twist it and how to avoid contempt or compliance with the order. So if you don't draft an appropriate order and it ends up that similar things keep happening, well, A, they're not in contempt, and B, your client's going to come back to you and say, well, this is precisely what we were trying to prevent. Why didn't you be more specific? Or why weren't you clearer as to what we were trying to prevent them from doing? And so you've made a problem where it didn't have to be, simply because precision matters in our business, and especially it's going to matter when we're talking about a preliminary injunction or a permanent injunction, because in order to be in contempt, there has to be a clear order and an ability to comply with that order that they were aware of. And if the order is vague, or in this case doesn't exist because they incorporated by reference, there's not going to be contempt. Go ahead.
So I thought it was the judges or the court's role in drawing up a contempt order.
Hey, fair enough. It's supposed to be. But judges are lazy. A lot of times on a motion, they'll simply write on the side of it allowed. So you want a PI, you got to draft it. You've got to put it before them. Here's the order I would like signed. And maybe lazy isn't completely fair. But the fact is, if I want something, then I need to make sure it gets done, right? Human nature being what it is, after too long, that if you want something done right, you better do it yourself, okay? And so what's the big deal? I've done all the other work. I'll draft a one-page order. The defendant is hereby enjoined from doing the following, right? Put a blank line, put the judge's name underneath it, and ask that that order be signed, right? Then I've got no one to blame if I get that order but myself. That's why you better make sure it says precisely what you want. And like anything else, after you've done that, look at it and say, okay, so is this sufficiently clear, and does it cover every situation that I'm trying to cover by this? And if not, then take another look at it, revise it, and redraft it. Because what you've got to remember here is that if they can't be held in contempt if the order didn't cover the alleged violation, or the order was sufficiently ambiguous that they thought that they could continue to do whatever it is that they're now claiming, right? I was just watching online the Roger Stone hearing this afternoon with respect to whether he's violated the gag order and the rest of it. You got to be the order has to be clear. Obviously, in that case, it would have to be constitutional, and he's got to be made aware of the order, and he has to have the ability to comply. And not every adversary is Roger Stone, but the fact is that most of them want to try and avoid whatever it is that you're trying to impose on them, and so you want to be careful with that. Here, there was a lack of, to me, they were kind of careless in the manner in which they allowed this to take place, because know now, Rule 58 requires that there be a separate order with respect to what it is that the person is being required to do or prevented from doing. That's the whole idea behind Rule 58. You can't just incorporate it by reference as happened here. You've got to be able to tell them what it is that they no longer can do, or that they are permitted to do. And so that's where we start out with here, is the problems procedurally with not setting forth separately what it is the court wanted them to do. And the reason it becomes really important, as it says in notes 4 to 6 here, is that it can't be punished by contempt if it's not sufficiently clear as to what was done. So the district court judge entered his order adopting the magistrate judge's recommendation. The cookie company successfully moved for an order requiring the corporate defendant to post a $10,000 injunction bond, making that motion that the company acknowledge that it was enjoined. So this, by the way, this was at least initially done by way of a counterclaim. We've talked about that. We almost always think of injunctions being granted to the plaintiff, and that generally is the case because they filed the complaint. But a defendant can obtain an injunction, but in order to do so, they have to have a legal injury, right? The injunctions are just not issued by themselves. So in order to advance their legal injury, they've got to do it by way of counterclaim. So as long as they have a legal injury that they can represent and plead for and seek damages or relief under, then there's nothing that prevents a defendant from getting an injunction either. But beyond that, you can't just seek an injunction because you want it. You have to have a legal injury. And so what happened here is that it was the defendant who sought and obtained the injunction preventing the franchisor from shutting them down. And then it says they were required to post a $10,000 bond. We're going to do another week, we take a higher look at this whole idea about the bond, but I want to mention it now. The court under Rule 65 requires the moving party to post a bond. That's what Rule 65 says. The bond is supposed to be surety to compensate the non-moving party, the person who's being enjoined, for any damage they may suffer while that injunction is in effect, if it's later determined that the injunction was improvidently granted. So in essence, if the Court of Appeals decides, wait a minute, district court was really wrong, they never should have done this, then they vacate the injunction. The party who was enjoined by that improper grant can now come in and say, hey, listen, I lost a lot of money here in the process. I want to go after the other side and obtain that. The surety bond is supposed to be there to compensate for those losses. So a $10,000 bond isn't nothing. We're going to see other cases where it should be more and the court might order less, but we'll take a look at that. But I just need you to understand that what the idea of what that bond is supposed to be about, because that bond down the road we're going to see gives us another thing to argue about and potentially prevent the injunction from coming into play. The order granting the motion to require the posting of the bond states the parties to comply with the contract. And to me, I don't agree with the court. It says, as terse as this command is, we think it placed the company under a legal obligation enforceable by contempt or other sanctions should it violate the terms of the franchise agreement while the PI was enforced. I mean, I don't disagree with that logic, but I think, especially in view of the discussion we've had with respect to specificity of orders that order injunctive relief, to me that's pretty vague. I mean, I guess I know what I'm supposed to do, but this is part of the problem. We disagree on the terms and interpretation of the terms of the contract. So to me, that order should have been a lot more specific, but the court says at the end of that paragraph, it was a scandalously inadequate form of injunction, but it wasn't a nullity, so therefore it's appealable. Okay, I get it. I don't necessarily agree that the order, I do agree that it's scandalously inadequate. To me, I don't see how you'd likely be able to hold someone in contempt under those circumstances. But let's look a little bit at the merits of this and the five-part test and the like. So we've got the plaintiff suing to shut their franchisee down, and because of a number of problems with respect to the way the franchise was run. We have the cookie vendor saying, listen, if you shut us down, if you strip us of this franchise, not only are we going to be out of business there, but my father, who guaranteed the loans themselves, he will lose everything, right? And so if you want to talk about irreparable injury or harm, it says the Siegel used borrowed money to invest $125 to $130 in fixtures and other improvements. Father-in-law and father, pledged 2 houses, his retirement fund, everything we're going to lose if we lose this franchise. And they feel that that's irreparable harm or injury, the fact that they've pledged everything and are likely going to be destitute if this happens. So let's look at the merits of it with respect to the 5-part test and the like. Why is the cookie company wanting to take away this franchise to begin with? Because if the franchisee's running a good franchise, then everybody wins. They get to buy product, and everybody's making money. When you looked at the problems that the Siegels were causing at the franchise, do you think that these were sufficient that would justify the company coming in to take away the franchise, or are these sort of minor inconveniences? It says that they were bouncing checks. They were payments were late, oftentimes. They flunked several inspections by the company's representatives with respect to the preparation and cooking of the food. They found oozing cheesecake, undercooked and misshapen cookies, runny brownies, chewing gum stuck to counters, and ignorant and improperly dressed employees. Do you think that warrants the termination of the franchise and cutting them off of these, the ability to make money when it's going to cause, as they say, so much hardship, or have these folks caused their own hardship at this point?
Sounds pretty gross.
So you wouldn't buy cookies from them?
No, I wouldn't buy oozing cheesecake.
Well, and then, the other part of it is that they then actually went and bought batter at like Market Basket or somewhere else, right? I mean, the whole idea behind franchise is to have some consistency and quality controls. And these folks seem like they're doing whatever it is they want to do, and potentially, that affects the cookie company's business. The cookie company tried to tell the Siegels that they need to cure this, and they were, I think, appreciative that there was another store that the Siegels were running that seemed to be run much better, but the fact is that there's numerous breaches of contracts here. Oh, by the way, I don't think I even brought up, and one of the problems is they were underreporting their sales, right? So part of the fee you pay is based on your sales. So not only are you cheating with respect to paying the invoices late, bouncing checks and all the rest, you're also stealing from me, right? By underreporting sales, you're stealing from me. By using batter that doesn't belong to us, that we don't even want attached to our cookies, you're in essence stealing from us by not buying the proper product. I mean, this has gone, as the plaintiff sees it, very, very bad, and they no longer want to deal with the Siegels. And yes, the Siegels are going to be financially hurt by this, but does that really amount to immediate irreparable harm under what we would see as the terms of the contract? No adequate remedy at law. They want to strip them of the use of the intellectual property. They say that money damages at this point are not going to do it. You can't allow them to continue to operate a franchise like this. It damages our brand. We want out. Likelihood of success on the merits, too. Are there likely numerous breaches of contract here by the Siegels? Sure seems it, right? And, you know, sometimes we could argue, well, some of these seem a little minor, you know, the runny cheesecake, misshapen cookies. But it's a food business, right? I mean, part of it is, if you're not doing things appropriately, it reflects poorly on our business, and people talk. And by the way, I think it'd be even worse these days, right, with all the social media. So a couple pictures of the runny cheesecake and runny brownies, chewing gum stuck to counters, so dirty and poorly cooked food. Yeah.
But if we have to balance that with the investment that the Seagulls put in, why wouldn't we rather give them some amount of regulatory injunction instead of just stripping them off?
Well, let me, because I thought at one point, I don't see it, I'm not seeing it right here. I thought at one point they even said, why don't you give us this franchise back and you can run the other one? Because the problem isn't with the franchise where they really are overseeing it correctly. The problem is this franchise. And this is the one where as they say, rampant violations exist. But the hardship here is really going to be visited upon the Siegels. So let's get to that. That's the third one, right? Immediate irreparable harm and balance of harms. Let's take the 3 and 4 together, because I'm not sure there's any public policy issues here anyway. Do those, the first two, if we're going to give to the cookie company, do the next two really, do they weigh strictly in favor of the Siegels? Or are there equities that say, well, wait a minute, the franchisor is being hurt by these activities as well. They no longer want to be in business with someone they think is cheating them and stealing from them and not living up to the terms of the agreement. So if you want to look at the balance of harms instead of immediate irreparable harm, I mean, they're both there, but there are equities here on behalf of the plaintiff that exist as well.
I think it's a double-edged sword, and it cuts both ways. Both can argue that there's an immediate irreparable injury. They can say that they've damaged their business by producing such, inept goods, and then the other way around, they can say that they weren't given enough training and the like.
But they did give them an opportunity to try. There's not a breach, right? There are numerous breaches, both financial and from the standpoint of the quality of the product they're distributing, as well as the quality of the premises and staff that are doing the work. The fact is that how much, are they? It says here somewhere, are they their brother's keeper? Right? Do they really have to, as contractual adversaries at some point, do they really have to forego the problems as they see them as significant simply because this is going to have a horrible financial impact on the Siegel's father and themselves as well? I mean, make no bones about it. This is going to be crippling to them. The loans will be in a default. Not only will the Siegels themselves lose likely their homes, but their father, who's likely much older, is going to lose his retirement income, his retirement nest egg as well. I mean, the results at the end of the day are going to be extraordinarily harsh. So what?
I think
I'm not my. Go ahead.
I think the trial judge was actually ruling error as far as the ruling for the Seagulls were concerned, because he was balancing the harm in such a way that, well, these guys have a lot of assets already invested in this, and they've already lost everything. And when you look at their harm, it kind of like preponderous as compared to the cookie company. So you know what? I will grant these guys their
Well, okay, so what about that? I mean, the cookie company, okay, we got some image issues, we got some things. The harm to the Siegels is everything we own. So are they right then, though, that is that type of immediate irreparable injury that we have to forego for the duration of the case? Because it doesn't really change, does it, that there's a significant breach of multiple breaches of contract here, which means at the end of the day, when this goes to trial, they're out. Unless they can work a deal in the meanwhile. So are we just forestalling what's likely going to take place? I mean, because the harm to the cookie company, who can afford it to a greater extent as well, right, is certainly dwarfed by the Siegel's harm is going to be everything they own. So they win, because I don't think that's where we're going here, right? I hear the argument, and I do think the court sympathies were with them, even though, on the facts of it, they're not that sympathetic. They're cheating on the money, they're cheating on the product, they're running a really crappy store. Like, you wouldn't go back if you bought these cookies. I mean, if you saw the premises that cooked them, you might not eat them, and you wouldn't eat them in the first place. I mean, it makes you wonder what else it might be problematic with this company that's cooking stuff. But that can, in fairness to the plaintiff, you got a bad meal, or you get food poisoning at Applebee's. You're not going back. You may not go back to Applebee's for the rest of your life, and you're going to tell Chili's, wherever it is, you're not going back. And now these days you're going to tell your friends, and they're not going back. So, I hear the problems that they're saying, and I don't find them insignificant either. And yeah, it's going to have a harsh result on them, but what the heck? What the heck? I'm not your keeper. You're going to screw up. At some point, you're going to have to pay for that. And so the Siegels say, well, we had no choice but to infringe on the cookie company's trademarks because they wouldn't give us cookies anymore, so we had to just simply go and use this other dough. I mean, to me, yeah, you could have, and you chose not to. You chose not to try and clean up your act and work with them. It does make a reference to this unclean hands doctrine in equity. One who seeks equity must do equity. You can't come to court with dirty hands and expect them to help you. And frankly, it's a pretty good argument here, right? The Siegels have pretty dirty hands as a result of all of their various breaches and dishonesty. That's tough that the court then sort of goes out of their way to help them, because that's pretty axiomatic in equitable principles, is that if you don't do equity, you don't get to seek it. And if you have unclean hands, we're not going to help you. And I do think the Siegels' hands are pretty dirty here. And there's a lot of fraudulent conduct, as the court says, that they committed here. So at any rate, the court's got to figure out what the heck they're going to do. And what we have is a basic contract dispute. And I just want to, it says, the idea that favoring one side or the other in a class of contract disputes can redistribute wealth is one of the most persistent illusions of judicial power. Listen, we might not like to have to do what I think the law compels us to do here as a judge. And it does seem that the equities, or at least if we want to think about sort of the root for the little guy, I think that we all value and like to do against the bully. I'm just not sure Great American Cookie Company is the bully this time, right? I mean, I felt worse for that guy who owned the little dairy, the little 7-Eleven store that they were taking away. He didn't do anything wrong, and they still took his store away. because the contract allowed them to do it. And here we've got a contract that there are multiple breaches to. And yes, the little guy is gonna take it in the neck pretty badly here, but it's not the judge's job to redistribute wealth as they would like to see it. And again, especially for someone whose hands are not clean, right? They don't come before the court free of multiple, not just breaches of the contract, but dishonest actions, right? The underreporting of the income, the bouncing of the checks, the using other people's product and calling it the company's. Their hands are pretty dirty here. The cookie company had appealed the grant of the preliminary injunction, but they also were appealing the denial of their own motion for a preliminary injunction to strip the Siegels of the trademarks. So not only does the court decide that the district court, in this case, improperly found the Siegels would be suffering from irreparable harm, I think this court felt it was much more self-created harm that the Siegels were suffering from, so that injunction, granting them the injunction was improper. But the court also visits the situation with respect to the cookie company's injunction to put the Siegels in essence out of business. And for whatever reason, they didn't oppose it, or they didn't reply to that part of the case. And so in essence, their lack of reply shows no opposition. Not only are they going to lose with respect to the receipt of their injunction, but the cookie company now has the ability to strip them of the trademarks and ultimately then likely put them out. You've got a dissenting opinion, and the dissenting opinion does talk about the discretion that the trial court generally has with respect to injunctions. And we've talked about that, and we've seen that in other cases, where as long as the court undertakes that five-part test, that they have the ability at the end of the day, assuming that the five-part test is in fact applied, the court has a great deal of latitude as to whether to grant or deny the injunctive relief. And I think that is in fact what the dissent is arguing about here. They're saying, listen, you folks on appeal who didn't actually hear the witnesses as the trial court did, you're going in and making a decision on this balance of harms. And I don't necessarily agree with you that the balance of harms tips only one way, or tips decidedly one way or the other. And as he has pointed out, it says, it seems to me obvious, painfully so, that the Siegels have far more to lose than does the cookie company. And I think that's right? That's the whole issue about the Siegels will lose everything, and the cookie company, it's probably likely not even a blip on their radar because of the assets and the long-standing history they have. And so I think the Cudahy's dissent is really taking aim with, if we say that the district court has a wide latitude and discretion in deciding to grant or deny injunctive relief, then how can we go in and, in a situation where there's clearly harm, say it doesn't tip as the district court said it does, and that in fairness, there shouldn't be some more time to sort of sort it out. To me, the problem at the end of the day is, even if you don't get the preliminary injunction, I think there are multiple breaches of the contract, so they will not survive at the permanent injunction stage, and they're going to lose at the end of the day. So why should we allow them to continue to damage the plaintiff's reputation and brand by offering such inferior product that is far below the standards set by the franchisor. The dissent says that they think the Court of Appeals has gone too far and ignored the discretion that the trial court generally has and does have in granting injunctive relief. So it's in fairness, he thinks that the the franchisee shouldn't, the vacating of their preliminary injunction violates the discretion that the trial court generally has. And it's not an unfair argument. The problem I have with it is still, at the end of the day, okay, so if the preliminary injunction stays in effect, I don't see how, based on all the various breaches, that they would ultimately be successful in saying that these didn't constitute breaches of contract. This court says he thinks they're relatively minor breaches. I'm not so sure that's fair either, based on the facts that they recount, that the majority recounts. Questions on the case? So what we see here too is this whole idea about the specificity of the order, and as vague as this one was, the court still allowed them to appeal it. I think you would have had a very difficult time enforcing contempt under the circumstances of this order. So I think it's important for you guys to recognize that when you're seeking injunctive relief, you want to make sure that you spell out the order exactly what you're looking for and make sure the court enters such an order under Rule 58. And to the extent they don't, you go back and get the order signed and you get the order issued that you need, because at the end of the day, you're going to have to try and enforce that order by contempt. And if there's an ambiguity or a vagueness about it, then the defendant won't be in contempt and you've wasted a whole bunch of time. Questions on the case? Okay, we're good. See you next week.
Is the recorder still on? Hi, John.
Oh, you want it to be. You want it.
Because he came to me and said, I heard your voice, so I want to say hi to him.
Shout out to John. I thought you wanted it off.
No, I wanted to.
I had a question, really goes back to that order.
Yep.
When you get the order, you're a counselor, you're telling your client, what you can do, what you can't do. Where is that line between telling your client, advising them how to circumvent the law?
Yeah, nope, you got, and that's a very good question, and here's the point. I would tell them, hey, don't play games here, okay, because it's not going to be me held in contempt, okay? The court's order is relatively clear. If you want to try and skirt it and play games, then no matter what, we'll be likely back in contempt. You are not supposed to do X, Y, or Z, and to the extent you get close to the gray line, then we may well be back in contempt. And if you are in contempt, the court can put you in jail in order to ensure compliance or to vindicate its authority. It's not worth it. So to me, I would be, if there's specific things they want to know that can we do this, then I would give them my interpretation. But I would also be abundantly clear to them that this is not something you mess around with, because it carries with it the threat of contempt. And I'm doing that more importantly as well, so that when they do get called in contempt, they don't say, Ray said I could do this.
Right.
And that's the other, and that's another thing I want to say, and it's really important in this regard. It's not necessarily what we say, it's what they hear. And you've got to be really careful with that, because people hear oftentimes what they want to hear. And so they're not even always intentionally lying, but they heard that I could do X, Y, or Z. And you don't have to say it, and they don't really mean to lie about you saying that. It's what they heard. And that's why you want to be careful, especially because I've said this to you guys a million times, not a million, but a lot. First person under the bus is you guys. We aren't family. I pay you to represent me. I can discard you and get someone else. So, to me, it just, you know, the way this works is, and you don't want to be in this situation where you have to account to the court for your actions. And so I always err on the side of being overly cautious and saying you have to be careful now, because the risk is here, if you do violate this, you could go to jail.
So do you put that in writing?
Yeah, I think you should. Yep, I think, because otherwise, again, it's what I said. It's not what you say. It's what they hear. Well, look, this is what I said. Okay, now when you say, "Oh, I said you could do X, Y, Z," that's not what that letter says, right? Letter says, "Dot your I's and cross your T's and clean up your act, because we'll be back here." And frankly, in a lot of these, they may have a lot. Look at the person you're fighting here has a lot more money than you. You must be doing this in part because you're running out of dough. They're going to keep coming after you. Look, they took an appeal on the order. The likelihood is if they had just played out the PI, they could have had it tried and won by then. But no, they took it on appeal instead. They got a lot more money than you, and they're going to go back in. So to the extent that you violate this order, you're going to suffer the wrath of that. You know, the Stone contempt hearing earlier today. At one point, the judge says, "I appreciate that the lawyers have apologized profusely." She said, "But the lawyers didn't do it, he did it." And it's true, because she didn't buy his representations at all. But so, we can be apologetic to the court for the client's actions, but at the end of the day, they're going to be the ones that are held accountable for it. So, I will see you guys next time.